On October 13th, Donna Adelson will be sentenced. And spoiler, she will be getting a life sentence because that is the mandatory sentence she must receive. Now, if you haven't watched the trial or my prior coverage, we already have gotten impact statements. So I assume it's going to be a chance for Donna to say something. She might not. She might put on more crying without tears. We're going to have to see. I'm going to take the guess that she's suddenly, again, not going to have to wear the headphones that she only needed to hear when the jury was there, to get her some pity points. Suddenly, as soon as the jury was done, they've deliberated, she didn't need those anymore. I still just remember that. With that out of the way, I have not actually covered myself the order denying Donna's post-trial motions, so let's get into them. This cause came before the court for consideration of the defendant's motion for leave to interview jurors. Yes, if you haven't been following along, she wanted to interview a couple jurors, and we'll get into that. Motion for new trial and renewed motion for judgment of acquittal, all filed on September 15th, 2025. The court having reviewed the defendant's motions, the court file, trial record, and being duly advised in the premises hereby find motion for leave to interview jurors. Defendant seeks to interview two members of the jury in her case, jurors 5 and 7. In moving to interview jurors, the motion must set forth allegations that are not only merely speculative, conclusory, or concern matters that inhere in the verdict itself. Consequently, juror interviews are not permissible unless the moving party has made sworn allegations that, if true, would require the court to order a new trial because the alleged error was so fundamental and prejudicial as to vitiate the entire proceedings. I might be getting that word wrong. So, we continue on. The defendant's allegations do not establish a prima facie case of jury misconduct, but instead encourage the court to engage in a procedure disapproved of by the Florida Supreme Court. So she's trying to get them to do something the Florida Supreme Court said not to do. And yes, I am having a late at night monster right now. The argued reason for interviewing juror number 5 is that he revealed he considered how defendant reacted to the evidence and testimony during the trial. However, there's always a however. Defendant also notes that juror number 5 expressly stated he did not consider her reactions during deliberations. Defendant's motion concedes that juror number 5 said he did not consider defendant's reactions when deliberating. This challenge primarily concerns that juror number 5 observed the defendant's reaction during her trial. By operation of fundamental, procedural, and statutory rights, the jurors are present in the same courtroom as the defendant. It is not impermissible for the jurors to visibly observe the defendant over the course of the trial. Yes, really at its core, this was Donna arguing, they looked at me. A juror saw my face. They saw the way I reacted. Even though they said they didn't take it into account, they saw me. The Florida Supreme Court in Phillips v. State found the fact that the 3 jurors briefly viewed a defendant in his jailed uniform was insufficient to warrant a new trial. The fact alleged here falls short of the argued prejudice found as insufficient in Phillips. Accordingly, the defendant may not have leave to interview juror number 5. So there's number 5 gone. Number 7 is the one that got a little bit more attention, I think. The argued reason for interviewing juror number 7 is that she posted on TikTok that she was selected as a juror on August 26, 2025. Defendant provided a video recording of this post, and the court was also able to locate the post on the juror's TikTok account, where it remains an active post as of the filing of this order. It displays the following text over the video of juror number 7. When I told God I needed a break, he makes it so I'm selected to serve on a jury for a 2-week trial. Won't he do it? Along with a caption that reads, no work, no kids for most of the day. You know what? Heaven, yeah. Juror number 7, and it has a link to it here. If you want to go, it's right there. There's the ID and everything. The jury was instructed not to communicate with anyone, including your fellow jurors, and this is italicized, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. An emphasis is added. The court concludes juror number seven's TikTok post does not constitute communication about the case. Rather, it was a comment about her jury service and its length. It does not reveal the parties, the attorneys, the alleged crimes, whether it was civil or criminal, or even the location of the trial. In other words, it was not about the case. As such, it is not juror misconduct. The TikTok post was not so fundamental and prejudicial as to vacate the entire proceeding. So basically, they got nothing, which I think everyone knew that like saw her pleadings. I think I covered it. I think everyone knew she had no shot. This was the best shot she had, and obviously it didn't work. Furthermore, every prospective juror was informed if you are picked for the jury, you may tell people that you have been selected for the jury and how long the case may take. So literally, she was approved to do this. However, you must not give anyone any information about the case itself or the people that are involved in this case. Attachment B. The defendant did not object to the jurors being able to disclose that limited information, and juror number 7's TikTok post comports with this exception to the communication prohibition. The defendant cannot now use juror 7's compliance with this directive as grounds to interview her. She literally followed the court order that Donna's people didn't object to. Accordingly, defendant may not have leave to interview juror number 7. The motion for leave to interview jurors denied as to both jurors 5 and 7. So that's kind of the annoying part that happens with people always want to have juror interviews and juror information, but every time it adds and I watch them too, right? I'm going to admit. But every time it adds a not zero chance that something is misconstrued or said and gets them a new trial. Didn't work. Doesn't work often, but it can happen. But obviously, these both were complete nonsense. You can't look at the defendant. You can't see their face. You can't see that they're... You know what? I'm going to leave it there. Let's continue. Contrary to the law or the weight of the evidence and judgment of acquittal, this is the motion for new trial, renewed motion for judgment of acquittal. So she wants to be acquitted now. I'm not going to read all of this, obviously. The court does not find the juror's verdict is contrary to the law or weight of the evidence. Court concludes a great amount of evidence supports the convictions. And it's just explaining members of the conspiracy and the different charges. The court also denies the removed motion for judgment of acquittal, relying on its denial of defendant's initial motion for judgment of acquittal. All direct and circumstantial evidence admitted, and evidence demonstrating the defendant's consciousness of guilt. Now we have decision of any matter of law which arose during trial. This is the planners, I believe. The court does not find error in refusing to admit the complete 2014 and 2023 planners. The state introduced the particular entries for the two calendars. Defendant asked to introduce a complete calendar during its case in chief. As an initial matter, the request was untimely under section Florida statute. Although the plain language of the statute requires the adverse party to introduce the other part of the statement at the time the first party introduced the statement, Florida courts have generally allowed the adverse party to delay introducing the other part of the statement until cross-examination. Defendant's request was too late because it came after cross-examination of the relevant witnesses. Okay. Even if the request was timely, it was improper because the purpose of the rule of completeness is to avoid potential for creating misleading impressions by taking statements out of context. By its very nature, a calendar day planner is divided into a series of pages corresponding with the days in a year. Thus, the court concludes the entries of the state admitted into evidence were not out of context. They were not one part of a whole. They were specific dates in the calendars referencing specific events, and those relevant entries were admitted in their entirety. It's been a bit, but I believe the argument the defense gave was the specific sections being used, if they had the full calendars, showed she was trying to sell things for a longer period of time, a pattern of keeping information, and basically the defense was trying to submit the whole thing to basically say, look, it's not weird she did this. She did things like this before and prior and with other people, and therefore it wasn't proof that she was involved in the conspiracy. Which I don't think it would have helped the defense if it was submitted. And in some ways, I kind of just wish it was, so this wouldn't be an argument. But obviously, that's not what happened. Um, Interpreting the rule of completeness to allow for every other entry in the calendars would require the contemporaneous admission of any written or recorded statement that might cast light on an admitted statement. Using the language, fairness does not require turning a trial into a voyage on a sea of hearsay. Accordingly, the defendant's invocation of the rule of completeness was properly denied. I mean, it would have been denied because of the timeliness of it, right? But I don't think it helped the defense or it would hurt the prosecution if it was submitted, right? I don't think it would have done the role the defense was trying. So yes, they're finding it was proper to not admit it. I don't think it would have. I would have preferred it just to be admitted. So I don't. Why not? Of course, hearsay is why, right? I get that. I get that. But like as a layperson, moreover, the court permitted defendant to use the entire set of calendar entries as a demonstrative exhibit during her closing argument. Again, right there, that's the thing where I'm like, so if we're using it in the closing argument, I know the closing argument, I don't know. Again, I'm just like, eh. The defendant argued the state did not want the jury to see them. I mean, the state didn't. I mean, I'm going to agree. The state did not want the jury to see it. They used it in the closing arguments. I wouldn't say that means the state wanted it shown there. In addition, the 2023 calendar entries defendant sought to admit would not refute arguments that she was fleeing to avoid prosecution when compared to the vast amounts of contrary evidence that existed beyond the planner. That's true. Such as the defendant's text messages, WhatsApp messages, Google searches for non-extradition countries, recorded conversations, emergency fast-track visa, and a one-way ticket to Vietnam. For other cause. The court does not find the arguments presented in this claim warrant a new trial, specifically addressing defendant's decision not to testify. The court relies on the trial record. After the defendant had closed her case, but prior to the commencement of closing arguments, the parties were asked to approach sidebar. The court explained it had performed additional research and wanted to confirm that defendant did not want to testify. The court added, the reason why I am bringing this issue to the party's attention is only because I believe the appellate cases of the state make clear, prior to instructions in closing, the exercise of the fundamental right leans towards allowing the defendant to reopen her case if she wanted to testify. Upon the court's inquiry, counsel responded, we talked to her for a somewhat lengthy period of time last night over the phone while we were preparing. She informed Miss Fulford and my paralegal that she felt secure in her decision. Defendant was then placed under oath and asked if she absolutely firm about this decision not to testify, and defendant twice responded, yes, I am, but asked for a few minutes to talk to counsel. The court then granted the additional 30 minutes for further to discuss her decision. After that time had elapsed, defendant once again stated, I have made a decision. I am not going to testify. When asked if she was firm on this decision, defendant answered, I am. The court concluded, I will make no further inquiry unless the state of the defense seeks for the court to do so at this point. The court, let's read the note at the bottom. The court also clarified its reference to contempt was related to defense counsel not timely returning from their conferral with defendant in previous day. After being instructed, they had exactly 5 additional minutes to discuss the defendant's decision not to testify. Defendant and counsel did not seek additional clarification on the matter. For additional context, the court attaches a compilation discussion concerning defendant's decision not to testify that precipitated the court's warning, including when the court mentioned that whether the direct will start this afternoon is a separate matter from whether she is planning to testify. And then we go back up here. Neither party did. Accordingly, the defendant was provided sufficient time and did make a knowingly, voluntary, intelligent decision not to testify. In denying defendant's other allegations, the court relies on the complete trial records of the proceedings, ordered in a judge that the defendant's motion for leave to interview jurors, motion for a new trial, renewed motion for judgment, and acquittal are denied, done in order the 25th of September, 2025. And here we have the reference sidebar. Court says, in researching some matters last night in anticipation of moving into closing today, I did want to confirm with the defense that the defendant is not asking to testify. Mr. Zellman. We talked to her for a somewhat lengthy period of time last night over the phone while we were preparing. She informed Ms. Fulford and my paralegal she had taken off her speakerphone at that point, that she felt secure in her decision. If Your Honor would like to have Ms. Adelson come to the bench, I can have her. The court says just have the bailiff bring her over here to the sidebar. Yes, sir, and the defendant is now present. Court. Mrs. Adelson, before we move on to the instruction in the law and the closing arguments this morning, I once again wanted to confirm with you that you are firm in your decision that you are choosing not to testify. Yes, Your Honor, I am. The court, you are absolutely firm in this decision? Yes, I am. Is there any further that you need to speak with your two attorneys on this matter? I would like a few minutes to talk to them. Yes, if I could. Add to this particular decision or some other matter. Ms. Adelson says, as to this particular decision. On this, I will provide a few moments. After this, we do need to resume timely. Yesterday, when the court made reference to contempt, this concern was continued to occur and does not return for the conferrals. We need to resume court. If you need to speak to your attorneys now, concerning whether you wish to testify, I will allow you to do so. I'm going to give you 10 minutes to accomplish this. When 10 minutes is up, we do need to move on. This is Kappelman. Judge, is it your intent to go right into instructions and closing at the conclusion of the 10 minutes? The court says that would be my intent. Mrs. Kappelman, I request 30 minutes because I need some more time to get my closing act together. So maybe that can give a little more time for the defense to do what they need to do as well. Both parties need to share their closing PowerPoints and demonstratives with each other too. Court will take 30 minutes then. The reason why I'm bringing this issue to the party's attention is only because I believe the appellate cases of this state make clear, prior to the instruction and closing, a request to reopen the case for the defendant to testify. The exercise of the fundamental right leans towards allowing this to occur. I'm giving her this last opportunity to confer with counsel and make this decision. Ms. Fulford, may I say something, Your Honor? If the state is done with their closing, we're going to need a break for time to set up our stuff. Court, that's fine. Will any recordings be used as part of the closings today? Yes. Mrs. Dugan, may I ask one more thing? Is it the court's intent to read the stipulation prior to jury instructions? Yes, because that will be part of the evidence in the case, and the sidebar conference concluded. So there is the sidebar. That's what you didn't get to see if you watched in court, right? So maybe people who've covered this prior have seen that. You've already shared that to you, maybe not. This is my coverage of it. Monday. It's probably not going to be a long appearance. We'll see. And of course, what do I see when I looked up people today talking about it? People asking, I wonder where Wendy is right now. And if she is going to be home, or maybe in a undisclosed location where maybe authorities won't find her. People are very much focusing on Wendy still. People that have followed this case. And I want to just point that out. She has not been charged. Okay. With all that being said, that will be Monday. So the plan for me is probably going to be this Monday. There's probably going to be nothing from me on Tuesday. And then Wednesday, I am going to have a early morning event on one game that then bleeds into the release of Pokemon like 4 hours later. So then I'm going to have to try to balance both of them because I want Pokemon and to do videos on my gaming channel, and it's going to be a mess. So don't expect much from me next week either, I will say, at least next week. I'll be still checking. I'm still checking for Sarah Boone stuff. I have to check her criminal case too, because I never know when a lawyer's going to quit. So hopefully you enjoy the content, and I'll see you in the next video. Probably going to be Monday after her sentencing, just to let you know what happened, whether she spoke or not. It's not really a question of sentence on Monday. It's more of, will she make a spectacle of it?